Hi, Sanjo. Olusanjo Omoniyi. We're delighted to have you on our program. You practice immigration law since 1996 and founded the successful Omoniyi Law Firm focusing on EB-5, business immigration, commercial immigration from Chicago to national impact. Could you kick us off with a quick walkthrough of your journey and how your background shapes your EB-5 practice? Thank you.
Yes. Thank you for having me, Marko. I graduated from law school in 1994 and worked briefly for an attorney in Southern Illinois. And in 1996, I went on my own and started my own. First in Southern Illinois, then I moved to Springfield, Illinois, then I moved to Chicago with a family. And I've always been in immigration law. My orientation toward immigration law started from the law school because there were so many things going on in around 1990s, the early 90s, because between 1991 and 94, one of which happens to be EB-5, okay? Because as I was stepping into the law school, they passed the EB-5 law in 1990.
Right.
I latched onto it, and I've never looked back ever since. In 1990, things were very rough. Initially, when the Congress passed it, nobody was using it. The implementation was very rough. In 1992, then they came up with the idea of allowing regional centers to get into the field. These are investment companies that help foreign investors to enter the U.S. There are two goals, and it has always been two goals behind EB-5. The first one is to economic development of the country. And on the second hand, it helps the foreign investors to migrate into the U.S. They come in as immigrant rather than with green card in their hands. It takes a lot of years to get things done, but I grew up literally with the industry, with my practice. I remember when we first started, the early participants who are the regional centers at that time, you won't believe it, they may not be around anymore, were almond growers, agricultural plantation growers. Some into apples and almonds in California. And then we had people migrating towards the real estate, okay? There was a big company that emerged out of Seattle, Washington, that oriented itself towards the construction of offices, commercial buildings, hotels, and things like that. Gradually, we've seen the development of the industry so much. There was no investment in the USA as a group, okay? Everybody was just doing their own thing because USA came into being about 20 years ago. And I could say I was part of early attorneys, okay? In Philadelphia, I remember this very vividly. In 2004, they heralded all of us who practice business immigration to a conference room talking about the need to create a body of attorneys that will be orienting towards the practice of EB-5. Encountered my first investor there who wanted my client to invest in the almond agricultural plantation in California. From there, various interest groups were rounded up into IIUSA. We have now security brokers, we have attorneys, we have plan writers, we have, each time I remember USA, how it all grew up, I was always feel elated to see how the industry had grown. Now we're talking of investment of billions of dollars in the country. At that time, Security Exchange Commission eventually got involved in the regulation of the brokers because they were the one regulating the brokers. The landscape was not well defined, but we grew. And this is an organization that should be very proud of itself, because those of us that have stayed with IRUSA and the industry, we've seen it growing enormously in various forms. The investors have also been very good. I've had to deal with investors. I made trips to China. I think the last time I was in China was 2016. I will have gone a little bit in the 20s, early 20s, but when the COVID came,
It's possible.
that shut that down. But I've always, the journey through the EB-5 has been accelerating. That's the word I will use. And I've had to do a lot of coaching, cajoling, encouraging people. We've got families into the country. One of them just called me 3 weeks ago that they got a family of 5, got their green card, the permanent green card,
Nice.
all the way from Nigeria. I've focused, I cast a wide net, okay? Because I've spoken to people from Morocco, Gulf area, India, and I'm taking Indian clients as of now, Chinese, but a lot of people initially were coming from Taiwan. So they came with various ideas of how they want to do or enter into the industry. The landscape is very, very filled up with people with different ideas.
Yeah. I mean, it is a good sack through to what I wanted to say. I mean, I'm coming from the other extreme, Sanjo, because
Okay.
I have been in Wall Street myself
Okay.
longer than I want to admit. When 1990 this EB5 was launched, we had no idea. All we
Okay.
knew is that the country is going through really bad. Many banks were in the brink of collapsing. I was in the derivative end of things, and credit ratings were just plummeting. So this industry on the side was growing. And when I came to this business, way after you, I've been here in this business for 10 years, only 10 years. And when I came in here and I started calling my friends in, Wall Street, in different companies, bulge brackets, and nobody had heard about it. It's an amazing thing that the industry grew to your point, to a level now in the last 10 years where maybe it was a primarily Chinese, probably other investors, but primarily Chinese investors. Now it's the whole globe, and it's regulated thanks to RIA. I think it's really gonna on the right path. So this actually want to ask you about best practices. You mentioned now immigration attorneys, regional centers, lawyers. You said plan writers, all the ecosystem. From your legal lens, I guess, what does effective coordination among these participants look like to ensure transparency, obviously avoid conflicts, and most importantly, I would think you would agree, protect the investors?
Yes.
What are the common pitfalls you see, and how should participants work together to make this a successful venture for years ahead?
Okay. You've mentioned the magic word, collaboration. Okay. We need the participation of various interest groups, or if we want to, share stakeholders. Okay.
Stakeholders, yes.
Okay. We have the banks, the financial institutions. We have the immigration attorneys, who you may say are the arrowheads of what we need to do. The broker dealers, okay, they've helped us tremendously because they came into the feed to help define the feed better. Because initially we had transparency that you mentioned was a problem, because the lawyers, they didn't know, a lot of other lawyers participants, because the field was not well defined, they were acting as lawyers, as brokers, and middlemen at the same time. So you'll be seeing some of them, they'll take money, they will charge the investors for introducing them to the regional centers, and they will then turn around and still handle the papers with the USCIS. So it's like we have a couple of people, not everybody are eating with 10 fingers at the same time. So with both hands, okay? As time goes on, we were able to start getting a Security and Exchange Commission involved, because they were the ones regulating these brokers, dealers. They start putting things in place that they literally would define what needs to be done, okay? Why lawyers should stay in their lane, and why brokers should stay in their lane, why both of them cannot be in the hands of the same person. That is, you cannot be a lawyer and broker at the same time. They encourage the separation of roles, by which lawyers will stay doing what they have to do, and the brokers will also stay in where they do best, which is dealing with the securities without getting into the immigration law, because once you mix both together, it doesn't mix. Then the regional centers, which were the business companies that were supposed to help all these investors put the money together or the project together or work on projects, they got better, because things were not well defined for some of them, because they house both the brokers in-house and the lawyers at the same time. But some, eventually, they got better. They start separating their roles, by which they will give the immigration paperwork to the immigration law attorneys. And they defined what the brokers can do for them as well. And at the same time, they work with the financial institutions, because the money that were coming in, as the rules were getting better, were being put in escrow. Okay? Some banks have specialized in how to handle the escrow account. So the regional centers do not have to have 100% control of the money, because that was one of the early concerns, where some regional centers, because they control the escrow account, they spend the money. Okay, so we do have, in the early part of, say, like 2013, 2010, 2012, with tremendous amount of fraud, because they find out that the investors' money, the moment they land into the escrow account of the regional centers, were being spent, even though the project was not off grant. We went through a lot in the industry.
Top patch. You went through a lot of top patch. I mean,
Yes.
I know the introduction of not only escrow but fund administration, I must say, is
Yes.
really the best thing that might have happened in RIA,
Yes.
because you're really segmenting now, and money is not going into the NCE, the new commercial enterprise,
New commercial entry.
managed by the regional center, but it's not going in there until the escrow agent has the go ahead from the fund,
Okay.
from the fund administrator. So I think you have a lot of eyes now in
Okay.
looking into. So I think it's I can't agree with you more. Yes, definitely.
Okay.
I think we should maybe move to another sort of a related topic here. You and I offline, we discussed, everybody is talking about now the new investors.
Yes.
Now everybody is talking about how great it has become for people who can invest now. But I think the people who invested before the RIA also deserve attention. I think you and I totally agree with that. Who, mainly, I would say the mainland China people and some others who are actually in the people from India also are backlogged. Checking the visa bulletin, and I found that the August 2025, it shows that the priority dates are on December 8, 2015 for the Chinese, China-born, and November 15, 2019 for the India-born applicants. Pretty bad. So I guess my question is filing under RIA set aside worth restarting for this group? In other words, doing another application, since their application is not seeing the daylight anytime soon. How do you advise clients with aging out children, for example, because of this issue, and the people who are doing dual filings, to maintain their situation? So what do you say about this?
Dual filing is acceptable if one has the money, okay? Although there's a lot of money to lay on the table, because to those who, speaking of the retrogression itself, what causes retrogression is the sheer number of the investors from each of those countries. In the past, we used to have Vietnam, China, and India. But over time, those two, India and China, seem to have remained unabated, because, like, I'll give you an example. In 2016, when I was in China for the conference, you noticed that there are 16,000 plus Chinese investors. Well, EB5 then and now still remain the same in number. We only have 10,000 per annum on the table.
10,000. Yeah.
Exactly. So when you have 10,000 visas, and
like 3,000 investors, kind of.
yes, and it becomes increasingly difficult to have, well, you have 16,000 from China alone. It means the whole worth of 10,000, we can give it to them, and they will still have 6,000 unfulfilled visa on the table. And mind you, this is just at the time in 2016. So it keeps increasing year by year as we go along. Okay. The same thing, we started seeing India rising in number as well, and Vietnam. Okay. So the progression. Now, all we have been doing in EB5 to a greater degree is we're kind of like tweaking the system up a little bit by inserting one rule after the other. One of the rules that was put in place was, hey, no country can get more than 7% of the visa. So 7% of the visa, if you have, it means like in China type situation, they can get more than 7% in a year of the total visa on the table. So imagine we have 16,000, and they just 7% of 10,000 is how much? 700.
So
So that is why the retrogression started. And in the world of EB5, it is first come, first serve for each country. Okay? So we're gonna go into, if we go into Chinese, we're gonna look at them and say, okay, you have 14,000 investors a petition on the table. We're gonna just look at, say, since you are entitled to just 700, you look at that, we are going to have to look at their years back. So, like the date you quoted of 2015, okay, it means that by the time we take the 700 of pre 2015 or around 2015, we will have exhausted that 700 that is allocated to China. Everybody else, after that 2015 for the cutoff, they're just gonna have to wait, because they've used all the visas for China. The same thing applies to the Indians. So the retrogression is not going to go out completely anytime soon. So to those who are in the retrogression logjam, they may have a few options. Okay. One is to possibly, if you can, withdraw your petition if it's that back to 2015, because it means you are seeing a waiting period of almost 10 years when in 2025.
Assuming that they move simultaneously, you and I spoke offline that it doesn't even move, simultaneously.
No, it doesn't.
You could be waiting for 20 years, 30 years.
In 2016, the waiting period was around 2012. It sounds like 4 years, but because the line keeps getting longer and longer, they keep pushing back.
Right.
Okay. At times, the availability of visas for China, we move like 2 months. So maybe we're looking at August visa bulletin, because the August bulletin issued by the State Department comes in by the middle of the month, every month. Mm-hmm. So we'll be able to look ahead what is going to come next month. Okay, in July, we're already looking at August. By mid-August, we will be able to see what's coming in September and on like that. So you may get to August 15 when another bulletin is going to come out. Then you'll find out that instead of March 20, half of them, there might have been a heavy number of petitions that was waiting, that 700 could have even been eaten up in 2015. So we may say, it's going to be February 2015 for September. Okay, we may regress by a month. Wow. We may move forward by 2 weeks or a month, but it has never been a big leap by saying 6 months to a year or something. We just don't get to that level. And the same thing applies to the Indians. Okay, what we are seeing in the industry, like I said, there's nothing against having 2 petitions on the table, but it has to be in a different form. And that's what I'm encouraging people, or they should seriously consider if they can afford it. Now, looking at the Reform and Integrity Act of 2022, that is where the possibility of that a new filing may come up in some cases. Okay, because in the old pre-RIA, most of it were not well defined. Okay, and the people were investing in hotels in big cities and urban areas and things like that, or where there might be a rural area that can be helped. But the new RIA, which will be put in place in 2022, gives us a path a little bit in that for the first time, with the help of USA and all the stakeholders, the Congress and everything, we now defined it that, we can have rural areas and has R1, R2 band where you can invest in rural areas. We actually have allocated visa that must go specifically, say like a rural area. We have like 2,000 visas could go in there. Then we have infrastructure projects, meaning that big infrastructure projects, it could be a dam, it could be a bridge, it could be, in some cases, we've seen in a number of places, educational institution where they're constructing buildings on campus. We have companies that specialize in working on a regional center that work on infrastructure. Their visa set up for them. By that changes the equation, because instead of people being locked up into urban area where they can hardly move and where the retrogression is heavy, if they choose to invest in rural areas, depending on the regional centers they're working with, I've seen people get visa from India within the first conditional visa within 6 months, 9 months, a year. The same thing applies to the Chinese. Okay, but the question is, but those who have already locked themselves up in the pre-RIA and they're stuck with those projects, can they talk to their regional centers to get out, to withdraw it? Or can they leave it there and apply for another one? And which because IRA gave us a lot of benefits. For instance, a case in point, if you are in the country on non-immigrant visa, even visiting visa, that lasts for, say, 6 months, if you plan it well, you can apply for EB-5 and stay in the country. The non-immigrant, once you file the paperwork together in the country, RIA gave us the opportunity to say, okay, you don't need to go back right away. You can stay in the country, and if you need to go out of the country, you can file an application for travel document that allows you to travel out of the country, and your green card petition is not going to lapse. You will be there. Concurrent filing. That concurrent filing helped us. It encourages people to do that. And to stay in the country, they will be able to stay on the side of the law. They won't lose anything if they invest in rural areas or infrastructure. They are likely to get their visa faster than investing in urban area where the waiting period is so long, and they're gonna get entangled to 6 years, 7 years.
No problem, Mark. No, we are doing the same thing, with our previous investors. We're encouraging them to speak to their regional centers. And, to the extent that they can get their money back, it's of course only 500. Somehow they have to tap it with another 300 at least for a rural urban TA infrastructure. You mentioned these set aside situations. But instead of waiting for, I would say, 10, 15, 20 years, they'll be able to get to your point in a year. For those who can afford it, while the money is there, hopefully it's not going to burn the 500, if they can come up with another 800 for the, again, rural urban TA or infrastructure, that's definitely the way to go. I mean, it's, I agree with you. Moving on, some emerging opportunities. We talked a lot about what I would call primary markets, East Asia, whether it's China, India, Vietnam, you mentioned South Korea, Taiwan, Hong Kong. These are all primary markets, groomed, so to speak. But there are other emerging opportunities. I think you mentioned about Nigeria, about in Africa. I think you mentioned there's also, of course, South Africa. There's Kenya. There's that group over there in Nigeria and maybe below. What should investors from these countries be aware of? Are there unique compliance or source of funds issues you encounter? We certainly do. Source of funds. Okay. What are the benefits EB5 can offer to investors from this region over and above other immigrant visa categories?
That's a good question, because unlike in the past with the RIA, what I'm advising some of the investors from these countries, and I imagine now we're now seeing Moroccans, Ghanaian, Nigeria, seeing from Congo, Angola, South Africa, and Kenya. The other countries here and there, and their focus should be, they should seriously consider taking advantage of the current array that we have, which now allows them to invest in rural areas and infrastructure. The one advantage with those countries, like in Africa or South America, is that they do not suffer from retrogression. Okay, because like I said, you only get 7%. A country can only get 7% of each year. You are not going to have any of those countries that I mentioned, Brazil, Argentina, South Africa, Nigeria. You're not going to have 700 petitioner or investors each year from those countries. They don't tend to be. Okay. If we look at the IIUSA roster of countries in the order of filing, Nigeria has a high population of filers. You may get maybe close to a few hundreds in a year, but there is nowhere close to 700. So there's never going to be a retrogression. That's number one. Two, what that means for them is that if everything is well planned out, they will be able to secure their visa, the conditional visa, the I-5 processed within a relatively short period of time. 6 to 12 months in some cases. The only thing that has now become an issue for a lot of these countries, and it's not just them alone. We've seen it in India and China, is that a lot of these countries has their own internal currency control. Okay, which means in some countries they have a limit of how much you can take out of the country. Okay, India is an example, but over time, people have means of doing it and addressing it because USCIS is very particular about the source of funds. It's a big issue, and I keep repeating it for everybody who answer questions about that. While we qualify, we give them a list of how you can obtain your money. Okay. Whether it is a loan, but if it is a loan, it cannot be a loan on your EB-5 project. And if you're going to pay it back, it cannot be paid back from the EB-5 you are investing in. So there must have been a separate collateral that will be used to pay that loan. In some society, they give the money to either the grandfather or father or parents. We give the money out to the petitioner. Okay, gift is good as long as we're not conditioning it on the gift that you have to return back at a certain time, which puts the EB-5 into question. It means it's not longer a gift; it's a loan. Okay, then. In some society, this is what I find out when I'm dealing with some EB-5 petitioner from the Gulf. They don't pay tax. There are no taxes in some of these countries, whereas the USCIS wants you to document how you hand the money. Handing the money legally is what we call it. The source of your fund must be legal. Okay, it could be where you work, you make money from your businesses. But in some of these countries, they don't pay taxes because and people will be asking, well, show me the document that they pay taxes. I said, no, there's no taxation in those countries. Or they will have money in the bank, okay, where they have the Islamic banking law. They will say you can't earn interest. What do you mean by you can't have interest? Well, that's just it. So the local law, if it's illegal in their country, I always argue to the USCIS, it should be legal here. Let's extend what we call reciprocity to their law. If they don't do it certain way and it's legal to them, then it should be legal here as well. So in some, if you win a lottery, as long as that lottery that you won is legal in your country, it is acceptable source of money, okay, in the US. So there is always comparative analysis about how you got the money, whether it is legal or not. The lawyer should step forward for their clients and explain why what happened over there. If it is legal under their law, it should be legal here. A case in point is landed property, where the grandfather will give land to a child, but they don't. The transfer of title is not neat like a title compliance in the U.S. But they put it in writing, they register it.
Recognized in the country. It's recognized that it's a legal.
Exactly.
They should accept it here, of course. They should accept the USCIS, should for sure accept that, yeah.
Yes, so you may have to explain it as a lawyer, do the explanation, give the in-depth analysis and legal analysis to it, and just to explain it to those who will be examining the petition, and that this is right, and it's legal in those.
Yeah, I mean, I agree with you that there are some countries where tax havens, let's say Caribbeans, with the Cayman Island, BVI, these places, you earn money and there is no tax. In countries like, maybe, I'm Turkish, I do a lot of Turkish business. And there is some very interesting law, I must say. If you have something, whether it is real estate or stock, it doesn't matter, own it for 5 years. After 5 years, the amount of money you earned from a capital gain standpoint is not taxable. So it might be very obscure for an American tax lawyer in here. It's like how can that be? How can you own something just because you owned it more than 5 years? When you sell it, there is absolutely no tax. Well, that's the law there. If a person bought something, let's say in 2015, and now is selling it 2025 to, come up with the money for the EB, and USCIS is looking for tax records, there's no tax. I'm just basically echoing what you're saying.
Exactly.
Because there is no tax once you prove that you've held it for 5 years. So I agree. I mean, these things have to be explained. I think more has to be explained. Some economies are just cash economies. I mean, in this country, everything is wired, everything is Zelle, or like there's some kind of a record, credit card, checks. The countries where people are coming from, for EB-5, even services, doctors, lawyers accept cash. I mean, this is the reality. They have cash. So when they get the cash, now they have to report the cash. Some amount is, some amount is not. So that finds itself in the bank. And then we have these source of funds issues. But I hear you. They have to be very careful in how they're documenting the source of funds. You mentioned about the path of funds, being the difficulty on getting the money out. But thank God, we've found that some different ways that people are achieving that, to bring the money. I want to go back, if you don't mind, because we talked a lot about the RIA, in terms of how it really reshaped the industry. And, it has been 3 years, March 2022 launched. So it's been over actually 3 years. I think it will be helpful to just, go through a little bit, maybe summary, what are the, meaningful changes, meaningful developments, processing times, what it affects the processing, the protections that have been introduced. We talked a little bit about the fund administration, escrow, but obviously there are others. All of this obviously have the investor in mind to make sure that the investors are protected. So do you think enough professionals and investors are taking advantage of this, of the RIA's developments, what it brought? And I guess this is for many of our clients who standing by the sidelines, like a wait and see. They see this gold card. They don't know it's going to happen. It's not going to happen. Because of the gold card, if I invest in EB5, I'm not really going to lose my money. Let me wait. So those people, what kind of advice can we give, you think?
Okay. Great question. I know we talk about gold card as well. RIA, which stands for Reform and Integrity Act, is actually doing its job. Okay, because yes, we want to reform what we had before 2022 because of the fraud and everything cleanup that needs to be, separation that needs to be, the landscape needs to be well defined so that we know what is acceptable, a legal source of fund, and the clean up some of the rough edges of having been applying the law for literally 32 years because the law, like I said, started in 1990. In 2022, we're grown up. At age 32, we ought to, okay, and do better because a 32-year-old person is more than a teenager, okay? We're grown up, and that's what it has done for the industry. We still retain the dual goals of the economic development in the country and giving visas as a reward to the investors. Then we throw in, like I said, by which you file everything and use the one-stop filing and everything gets submitted. You don't have to go back out. So it's as a reward to the investors. You can file it, stay in the country. If you don't have anything to do outside the country, you can stay until you get your visa. The third is that it gives peace of mind to the investors. Okay, can you imagine we're bringing all the 2 kids into the country and the wife and stay in the country? The kids get to go to college, high school, do everything without worrying, being non-immigrant, even though they are non-immigrant until the green card is granted. But we give them that opportunity to stay and enjoy what they have in the country. Then there's the issue of short-term panel by which the people can invest in different areas. The rural areas gave us is like a thunderbolt from nowhere. It's separated. It's well defined, unlike in the past where we used to have to argue. States get involved. Every state wants to classify their economic areas as area. Then the Economic Development Agency of several states, I used to know them, have them on my Rolodex RIA and there's some of them cooperated. I have no problem with them, but the RA cleaned it up a little bit better. Now we know that the certain amount of visas are allocated to rural areas, and we have it rural 1, rural 2. I'm not going to bog the listener too much definition of what constitutes a rural 1, rural 2. But believe me, if you talk to my office or any EB5 lawyer, they ought to know what they're talking about, and they can verify how many visas are available and where you can pick up their form and check. We have records now. This is the age of electronics. You can check which regional centers introduce rural areas projects. The same thing with infrastructure. We can know which company have infrastructure projects. So by doing early work from various sources, we have the IUSA has the data bank of data and information of members. You can guide the investors in the right path to get it going. Then something happened though. In October 2023, USCIS almost wanted to pull a rug under our feet because we just won RA 2022. One of the advantages we got at that time was the law was supposed to last for 5 years. It's steady until 2027. Okay, because in the past, Congress have to pass a enabling act to keep it going almost on annual basis. And the lobbying will and going back and forth with politics involved is not that savory because it takes a long time to but then USCIS saying, hey, without overnight, right there on their website, they said your sustainment period is only 2 years. Mark those two, they mean maybe 3 or 4 words, only 2 years, 3 words, okay? It is significant. Sustainment period to the stakeholders in the EB-5 means the period you get to have your money in an investment in an EB-5 project, and so you will consider that period as the period where you are exposed to the risk of losing the money. Okay, I don't know what USCIS is trying to do by saying only 2 years, because what they seem to be saying, okay, you only need to invest your money for only for 2 years. It could be, it looks like a big problem, because to the regional center, can you imagine where they turn around as an investor and say, I only need to invest it for 2 years. Hey, I want my money back after 2 years, but they have not been given even the conditional green card. Okay, the pressure will have been too much. So what they did there violated what we call Administrative Procedure Act. Okay, APA. I used to work in an agency, an executive branch like USCIS, executive agency wants to do something. They take the law passed by the Congress. They want to apply it. In the way they interpret it and apply the law, they have to put together rules and regulation. Okay, that rules and regulation requires that they put out a notice to the general public, all the stakeholders, saying, look, USCIS wants to apply the law on so section of the law. We want you for the next 60 days to comment. Notice and comment is the law, is the rule for an agency like USCIS. They didn't do that. They just put this is what we're gonna be doing. Everybody said, wait a minute, where is the notice and comment period? That's against the law, what you just did. That's why USA and other stakeholders took USCIS to court in DC. And that's why we have been going on that, saying, because the law should have been said, because the old law says not less than 2 years. That's a major movement where we used to say not less than 2 years to only 2 years. That's more draconian in nature in terms of application of the law. That was what led to the sustainment lawsuit. Everybody has talked about it, and we want them judge handling the case knew what was going on. Okay, and the parties have been talking back and forth. One thing we don't want them to do, though, we don't want them to go back to the old law, okay, to the old rules of not less than 2 years type of thing, because it has so much problem to it.
The old law it is still the law in terms of the permanent green card application. So you still cannot apply for your 829, as far as I know, unless you are 2-year conditional. You have a 2-year conditional green card. But as far as the payback of the capital, so there's the immigration aspect and then there's the capital aspect. The capital aspect, they're saying that you can, regional center, pay back the money in 2 years. I don't think they're saying you must, but they're saying that you can pay it in 2 years. My understanding of the problem is that even though we as the broker-dealer are supposed to check that the investors understand the risks that they're getting into. They're accredited investors. Unfortunately, there are those who, in addition to their objectives of green card and money back and interest rate, those are sort of three. The fourth one being the tenor. I have a lot of investors that ask me, what do you have short term? What do you have short term? 3 years plus one. What do you have short term? So to those, I explained this. So I think regardless of whether USCIS or IIUSA is going to win this argument, there's still, for investors who choose to invest in a project that is 5 years plus, a few extensions, there still will be a room. I think the problem here is the industry's, reputation. So if USCIS were to win, right, and if it becomes legal to return the money in 2 years, what I think could happen, and I think that's probably what IIUSA and others are worried about, is that these sort of last resort, type of people are going to come in and collect the EB-5 money because, you go to the investor and the investor doesn't see, if especially they don't have a broker dealer who's guiding them, that showing them the risks of the project. They look at the, projects look the same. One is 2 years, 3 years. The other one is 5 years, 6 years, 7 years. Of course, they're going to go and buy and invest in the 2 year, 3 year one. So I think the lawsuit there is trying to avoid a situation where many projects are failing. And how newspapers, how news goes, some projects, even though they were risky, they were 2-3 year projects. And why they were able to collect the money? Because USCIS won, and therefore people invested in those projects. The industry will be tainted. So I think the argument here is that the bulge bracket firms on the one side who are arguing that it should be minimum 5 years. I think that's what they want. I think minimum 5 years. And USCIS is saying you can have 5 years, but we want to allow the regional centers who want to, promote projects that are less than 5 years, 4 years, 3 years, even 2 years. We want to. So that seems to be the argument. I think you can make a case for both, Sanjo, in my opinion, because these investors are supposed to be accredited. They're supposed to know what they're getting into. And if they don't, at the very least, they should be using a broker-dealer, whether they use our company or a competitor, I don't care. But they should have, legal guidance from, a lawyer like yourself, but at the same time, financial advice. From a company like us. And if you did have that, I think those projects were trying to collect money out of nowhere will probably not succeed in collecting. Yes. Well, this was very helpful. We covered many topics in here. I don't know if you have any last few words of advice, wisdom with your tremendous experience in this market. You probably, I would say, one of the, if not the most experienced, definitely on the top list there, experienced EB5 lawyer out there. So our listeners are definitely interested in your wisdom. And you shared some very, very valuable information with us today. Any parting words would be appreciated.
To the potential investors, I'll say keep believing in the EB5. It's a great program. We've brought a lot of people into the country through that, families of all kinds, and it's very good to the rest of the world. Spoken briefly about even though we didn't mention it in the great deal, President Trump mentioned the gold card. Okay, is gold card, even though a lot of people describe it as if it is EB5. It is not EB5. The Congress has not approved a law specifically for gold card. They will have to define it. They will have to take into account the experience. The EB5 community has stretched its out, particularly I'm not speaking for the USA, but as a member of this august body, we members more than willing to share ideas with them of the experience that we've had. I mean, this is 2025, 35 years of experience we've had in EB5. If they lean on the shareholders in the industry, they will have the ear full of advice of how EB5 works. It has not been thoroughly defined. Maybe they're still working on it. He requests that people put down $5 million and get it. And one of the few things that I've had, I think from, it might be Barry Litnick, who was discussing it. I think he's the Secretary of Commerce, okay, who was defining that EB5 with the president on the day it was launched or mentioned in the White House. The bottom line is the program. We actually give people permanent green card. Okay, that's totally different from what you're going to get in the EB5, the current EB5 system. Current EB5, we give you conditional green card for 2 years, then you apply for the permanent green card. So it's a two-step process, whereas the gold card is a one-step process, as the president was defining it, but it requires a much hefty sum of money of $5 million.
$5 million donation, I must say. It's not investment.
Yes, and that's what I'm saying. Not an investment.
In $5 million, in the gold card, $5 million, it's gone.
It's gone. You just give it to the government. It is not going to be tied to any investment. Okay. So we will see it when it comes out. Okay. But until then, anybody who is sitting in the sideline thinking they want to wait for a gold card, my advice is you don't need to. What you have to take care of now is the family, yourself, and getting into an immigrant visa program. If that is your goal, go for the current EB5 we have on the table, consult lawyers and other stakeholders. Brokers like you could be used and discussed, and you will be able to point them in the right direction because you are the professional in the security business. Lawyers will define the legal landscape, and we do work together. We should work together. The collaboration has been great. We see the benefits of that collaboration with each other. I read your articles on a regular basis and others. Then I say, okay, here's how a broker sees it. Okay. Then I can tell people, I say, look, this is what the gold card we give you, but won't give you. Okay. And this is what we currently offer. And we have tons of regional brokers, regional centers who have been in the industry. They've toughened it out. Some have fallen by the wayside. We could tell you what it looks like, and they give you a head up on how to evaluate what you want to do. Okay, so I'm glad that I've met you, and I've read everything you've been doing, and I'm looking forward to work with the investors around the world. I've been on the plane where I flew 15 hours from Chicago to Beijing or Shanghai. So I could tell a lot of stories. And we've seen the good, the bad, and the ugly, but overall, 5 years, it's been 35 years of celebration for EB5.
Thank you very much, Sanjo. Would love to have you again in our program, and all the best. Thank you.
Thank you.
Thank you.
Bye-bye.